The Child Status Protection Act, or CSPA, CISPA for short, is a special method the Immigration Department, or actually Congress, created to allow minor children who get too old, above 21, to stay as part of their parents' family based case, employment based case, or even diversity green card lottery. Less and less on that one. We're going to jump into how to do a basic calculation for a Child Status Protection Act, which is helpful, especially if you have a case that went to the embassy or USCIS and was denied. And a lot of times, many times, it's incorrectly denied. So you have to challenge them. So you have to learn how to do the calculation. I'm immigration lawyer John Khosravi. We help families get green cards and keep green cards. We run into the Child Status Protection Act issue all the time, and probably 1 out of 5 times the government makes a mistake in calculation. So we're able to help to get a visa, immigrant visa, or a green card for the minor child. So it's very important to listen to this stuff. Now, this whole CISPA situation is complicated. We're going to go over the basics of it, but there may be more complications that require you to sit down and talk with us in private and do more thorough analysis. Unfortunately, there's different nuances to the laws that could be problematic. If you deal with USCIS, Immigration Department in the U.S. is one way. If you deal with the embassy, it's another. We're going to go through some of that, but we can't go through all of it here. It's all intended for general educational purposes only. So this is a situation. You have a parent that's mom or dad, who's going to be getting a green card based on a family-based case or employment-based case in most times, and they have children. Maybe 2 or 5, they'll probably get in the case, but they might be 15, 20, or even close to 21. And by the time the green card is ready, they may be over the age of 21, so they fall out of the parent's case. Now, Congress in around 2000, 2001-ish created this special Child Status Protection Act to say, hey, listen, we could do a formula to allow the kid's age to artificially stay under 21. And that's this. You calculate the time it took for an I-130 or an I-140 petition to be approved. So let's say it's a U.S. citizen mom applying for her son and their spouse and kids. The time it took for that grandparent, essentially, I-130 to be submitted to, which is a priority date, to the time it took for the case to be approved, the I-130 case to be approved, could be deducted from a child's age. So if it's January 1st, 2010, the case started and was approved January 1st, 2013, that's 3 years the I-130 took. You could subtract that from the child's age when the visa bulletin is current, which is an idea we're going to go in a second. And so essentially, if the kid is like 22 and a half, that would decrease their age to, I got to do math here, 19 and a half. So it'll make him okay. So even if they were, 24, let's say, and a half, or 24 and, 11 months, that 3 years will be decreased from their age, and they'll be able to stay as part of their parent's case. But there's more to it, which we get into. So that's the first thing you have to do when people contact us. We need your approval notice so we could calculate the days for the I-130 petition, how long it took to know how much could be subtracted. The next things we need to know are the child's age, so we can see how old they were on the date the visa bulletin became current for their age. And this visa bulletin situations, I have whole videos going into this, but essentially visa bulletin is the line for family-based preference cases, and for employment-based cases, it's a line to show when you're able to get a green card. Now, if you have an immediate relative case, that's a child of a U.S. citizen in this scenario, you are already locked in for Child Status Protection Act as long as you file the case before the child's 21 years old. So that's a different calculation, but it's actually no calculation, just you're locked in. But for the other preference categories, you need to know the visa bulletin when it became current. So that priority date, the first date you submitted your I-130 petition, sometimes an I-140 petition, for example, for an EB-1A, or for those getting green cards for employment perms, the day the perm labor cert was filed, that could be your priority date. You have to see when that becomes current on the visa bulletin. You can find this visa bulletin by just typing out the word, again, visa bulletin, into Google. There'll be this charts that come up on the Department of State's website. For each category of family-based and then employment-based, there'll be 2 charts. I'm going to go over through what that means really briefly. But for most part, let's say your child is overseas and going through the embassy system, and it's a family-based case. You look at the visa bulletin called the final action date. This is the date that a green card could be issued. And when that becomes current, meaning the dates listed in that category that you're in passes their priority date, the date that you started the case in the beginning, then you could get a green card. And that's when it opens the ability for you to lock in the child's age. So if your case is pending and the I-130 is approved, you still need to do a thing called sought to acquire to lock in the age where it is, so it doesn't, if the case stays longer, it doesn't matter. But only time you can lock it in is when the visa bulletin for that case is current and you seek to acquire, which is filing for DS-260, paying a filing fee, for example. It could be submitting Form I-824. It's different acts to show that you want to go forward with the case. And along with that, they made it a little more simpler nowadays, and not simpler. USCIS said we're going to help people out and say that if there's compelling circumstances that prevented you from submitting that sought to acquire on time, it might let you come back later and do it. Also, they might let you just send a letter in to seek to acquire without paying a fee and stuff. Those are extraordinary circumstances. I wouldn't want to really mess with that. But essentially, once the case is current, you need to immediately act on it. You have 1 year to lock it in. So the child's age gets calculated from that date to see on that date were they, how old were they and how much we can subtract the age from to see if they're under 21 or not. That's when we're actually going to know if you seek to acquire in time. Now, sometimes the visa bulletin has retrogression. That means it'll be current and then it goes backwards. So it was current, you got to file quickly. You got to be on top of it to lock it in, because if it goes backwards, you can't lock it in anymore until it comes forward again. This is a complexity. It's one of the reasons we need to have a consultation to check all the visa bulletins for every month that come out to see which one is appropriate for your case. So let's see, you sought to acquire, you locked it in, and the kid's age is subtracted with the time the I-130, I-140 petition was pending, and the age comes under 21, then you're all set. Now, some more nuances. USCIS recently updated their policy manual, and this could change with new presidents, but they said they could use a second chart if you're doing the case in the United States to lock in the child's age. So you have more ability to lock in their age much faster and more chance of success if you're doing adjustment of status. You can file the case in the United States because you could use a second chart, the date of filing chart. Now, consular processing, Department of State does not formally accept that. They still use the visa bulletin, which is not as helpful because it's a worse off date for this kind of calculation. But from colleagues I've been hearing, randomly they'll approve it based on the date of filing, which is more beneficial. But because it's not official policy, they can always come back and have problems with that. So I'm hesitant in recommending someone do that. But here's the big picture. What you got to do again, you got to see how much time the case is pending, to know how much time can be subtracted. You got to see when the case could be locked in by seeking to acquire, depending on the visa bulletin chart that you're using and what month it was put in and when you locked it in. And you subtract the child's age from that time. You got to go through a visa bulletin and find that out. And that's the long and short of it, but there's always more calculations, more complications that come up with kind of stuff. So if you'd like to have a private consultation, go to our site, our contact us page, and reach out to us, jqklaw.com/contact. Again, that's jqklaw.com/contact. That should be the best way to contact us. We have a lot of fake profiles people make of us, and they try to take people's money unfairly and fraudulently. Contact us through our websites. We have a video consultation to analyze and investigate and calculate your child's child status protection in that case, to see if that doesn't work, what alternatives exist. Maybe they have alternative work visas that are available. Maybe the parent could turn around and submit for them in some other way. Maybe they aged out of one, but they could then move to another category potentially. There's all sorts of stuff. There's other scenarios where a parent might become a citizen, the child files out, then it can't be part of the CSPA age anymore. There's a lot of nuances that go into this, unfortunately. It makes it a lot of legal work. It's business for us, but I'd say that's not the best business, because I'm always sad when I have to tell a family that their 22-year-old child is living with them, can't come with them to America. They have to wait 8 years or something. That's always like horrible news that I hate to give. But hopefully we could give you some good news. Contact us at jqklaw.com/contact and have a video consultation with me, and we'll take it from there. I wish you all the best. God bless. Be safe, and see you soon.